The post office scandal is an indictment on the entire legal profession upon the assertions or accounts given by Mr. Jenkins, who himself cannot be confident that it is correct. The timeline shines a light over the villains behind this scandal, including past and current leaders and ministers of the post office, as well as parliamentarians spanning various political spectrums. Nevertheless, it is crucial that we direct our focus on the defendant in our metaphorical dock, the criminal justice system. Despite my reluctance as a fellow lawyer to highlight this, the post office scandal is an indictment on the entire legal profession, encompassing prosecutors, defense practitioners, and ultimately the judiciary as custodians of justice. Let's start with the prosecutors. It is clear that they failed egregiously to competently advise on reasonable lines of inquiries that ought to have been followed, to discharge their disclosure obligations, and to get to grips with the required evidence standard. I've heard many comments pointing a finger at Fujitsu, whilst no doubt Fujitsu had its part in it. As Mr. Justice Fraser stated at paragraph 1018 of his long judgment handed down in December 2019, the post office ought to have known how its own system works. We have highlighted all these issues in our video titled Post Office Scandal Lost in the Maze, which you can find linked in the description below. A second mention on this indictment goes to the defense practitioners. It is puzzling how so many people were advised and allowed to plead guilty to crimes they did not commit. Supposed masters and supposed mistresses were led to believe that it was acceptable that they pleaded guilty to false accounting. For false accounting to amount to a criminal offence, evidence of intent and dishonesty is required. And in these cases, such evidence was totally absent. However, ultimately, whom should we truly hold accountable for what Post Office Minister Kevin Hollenrich described as a brutal and arbitrary exercise of power? The ultimate gatekeeper in the administration of justice is the judiciary. After all, it is the judge who must decide whether a prosecutor has discharged its obligation as to the burden of proof. It is the judge who decides whether a defendant is being afforded a fair trial. It is deeply disconcerting and unsettling to comprehend how, in more than 700 cases, judges failed to inquire about the whereabouts of these missing funds, or did not rigorously demand solid evidence to substantiate the asserted and repeatedly claimed reliability of this supercomputer system. Effectively, the post office asserted the supposed masters had stolen money. Instead of presenting compelling evidence through computer trails, it forced the burden of proving innocence on the supposed masters. Despite numerous requests from several supposed masters and supposed mistresses for the disclosure of error logs, such requests were denied. In doing so, the prosecutor not only unjustly reversed the burden of proof, but also, by withholding computer logs, hindered their ability to meet this burden of proof improperly and unjustly imposed on them. He would have fallen onto the judge of first instance to point out that the prosecution had not adequately met the burden of proof and accordingly stayed the proceedings. In other words, the judge should have said, "We cannot simply take your word that the system is robust. You need to prove that the system is robust." In the matter of Regina and Seema Misra, Miss Misra's defense team brought to the attention of various judges on many occasions the issue of failed disclosure in relation to the Horizon error logs. The final attempt was before the trial judge, His Honour Judge Stewart, on the 8th of October 2010, on day 6 of the trial, just after the prosecution rested its case. Defence counsel contended that Miss Misra could not have had a fair trial due to the failure of disclosure of the error codes. This is what defence counsel said at page 21. He, Mr. Jenkins, accepted he had not seen any supporting documents, had not seen the reports attached which should have been attached, had not seen the raw material which had been downloaded according to this log on the 22nd of September 2005, which could have been available to him if he had taken it from the archives, but had not. So the Crown rely upon the evidence of Mr. Jenkins to say we can exclude any problems which could have occurred upon the assertions or accounts given by Mr. Jenkins, who himself cannot be confident that it is correct. Mr. Jenkins has also explained to the court that he operates under a restriction because he is an employee of Fujitsu who are under contract to the post office, and he can only comply with his contractual terms as best he can, and there is no suggestion his integrity is anywhere at fault as to what he is permitted to do, bearing in mind this is a post office prosecution. I don't go behind that, but it is not an independent prosecution at arm's reach from the loser company and Mr. Jenkins. So we have concern as to the quality of this evidence, the best he has done in regard to the restrictions he operates under. Despite that, the judge ruled against and determined that the trial was fair. Truly shocking. Miss Misra was convicted and sentenced on her son's 10th birthday to 15-month imprisonment. She was pregnant with her second son when she was sent to prison. She said that had she not been pregnant, she would have contemplated suicide. Judges are gatekeepers. The judiciary has for too long sought refuge behind the comfortable cloak of independence, abstaining from taking action when it was required and adopting a pusillanimous stance when ought to have criticized prosecutors, whether they were public or private. Instead, we had to wait until 2019 when a High Court judge, Mr. Justice Fraser, finally started asking the pertinent questions for the scandal to finally unravel in favour of the many supposed masters and supposed mistresses. That judgment was then the catalyst for the quashing of the 39 criminal convictions in the case of Hamilton and others and Post Office on the 23rd of April 2021. At paragraph 137 of that judgment, the Court of Appeal states, "In those circumstances, the failures of investigation and disclosure were, in our judgment, so egregious as to make the prosecution of any of the Horizon cases an affront to the conscience of court. By representing Horizon as reliable and refusing to countenance any suggestion to the contrary, POL, Post Office Limited, effectively sought to reverse the burden of proof. It treated what was no more than a shortfall shown by an unreliable accounting system as an incontrovertible loss, and proceeded as if it were for the accused to prove that no such loss had occurred, denied any disclosure of material capable of undermining the prosecution case. Defendants were inevitably unable to discharge that improper burden. As each prosecution proceeded to its successful conclusion, the asserted reliability of a horizon was, on the face of it, reinforced. Defendants were prosecuted, convicted, and sentenced on the basis that their horizon data must be correct and cash must therefore be missing, when in fact there could be no confidence as to that foundation. Since then, only 93 convictions have been quashed. So what needs to be changed within the criminal justice system so that this does not happen again? Based on our analysis, we can assert with confidence that preventive measures are already in existence, making it possible to avert scandals such as this. If prosecutors had adhered to codes and guidance, if defense counsels hadn't yielded to a culture of readily accepting guilty pleas, and if judges had prioritized listening to individuals rather than unquestioningly trusting powerful organizations, the scandal could have been prevented. This reinforces our repeated mantra that our focus should be on changing the operators of the system rather than the machine itself. Nevertheless, we acknowledge and have consistently emphasized over the past year that the current state of affairs concerning private prosecutions is utterly unacceptable. If you want to know more about private prosecutions and the Justice Select Committee recommendations, you can watch our video titled Private Prosecutions Problem Solved, linked in the description below. We are pleased to see that this issue has finally met some interest within the media. The headlines in several articles by The Guardian read: Top lawyer urges MPs to review private prosecutions after post office scandals. And another article: plans to reform private prosecutions after post office horizon scandal. Improved oversight and a law to strip organization of their power to take people to court are among measures gaining cross-party support. In May 2021, in the wake of the second judgment of the Court of Appeal in Hamilton and others and the Post Office Limited, in his written evidence to the Justice Select Committee on Private Prosecutions, Mr. Stephen Wooler CB wrote, equally important, the court's findings should dissipate any lingering complacency that what happened in the post office cases can be regarded as a one-off. In some senses, the scandal was unique, but could not have happened without our permissive regime, which allows uninspected persons to prosecute and trusts that defendants will be able to expose wrongdoing before it is too late. Moreover, such misfeasance over the course of a decade can hardly be characterized as a one-off. In fact, England and Wales is probably alone in allowing private individuals and corporate entities an almost unfettered right to exercise what is fundamentally a state power responsibility. The strongest single message in jurisdictions where the rule of law prevails is that prosecutions and punishment of crime is fundamentally a public state responsibility to be discharged fairly, objectively, and impartially by or on behalf of public authorities in the interest of society as a whole, the public interest. The anomalous nature of the England-Wales position is emphasized by the subjection of the main investigation and prosecution bodies to inspection, whilst leaving private prosecutions unregulated. That seems as logical as Ofsted inspecting state schools but not private schools, or CQC inspecting the NHS but not private hospitals. Now it has proven that a private company, Post Office Limited, was more in need of inspection than anyone. But the inquiry will come only years after possibly hundreds of miscarriages of justice were perpetrated. Things can go wrong under any arrangement. For example, the zeal of Customs and Excise that led to the Butterfield Review, serious disclosure failures within police and the CPS. However, oversight arrangements, where they exist, can provide assurance that prosecutors generally are acting to appropriate professional standards in terms of transparency, competence, independence, and fairness, and so reduce the inherent risk. Risk is at its greatest when a prosecutor has a vested financial interest in the outcome of the proceeding. The Post Office is a prime example. We hope that the government will finally look at the recommendations made by the Just Select Committee. I hope you found this video interesting, and if so, please like it to allow a wider circulation, and if you have not done so already, subscribe to this channel to be part of our community and help us with our mission to humanize wrongful convictions. Also, join our networking hub at spokeninjustice.net. Your presence will add another powerful voice to our ongoing conversation about making positive change and addressing the shortcomings in our criminal justice system. Join us again next week. We look forward to usher you as we sit and rise in this unique trial.